So by way of introduction, over the past 100-plus years, the U.S. federal courts have crafted a series of rules and tests concerning, A, when contractors are entitled to receive a time extension under a construction contract, and B, when they're entitled to delay or impact damages. And please keep in mind that just because you get a time extension under a construction contract, that may be excusable non-compensable, that is time, no money, or it may be excusable compensable, where you get both time and money. As a result, contractors, owners, construction managers are frequently involved in time extension issues, delay claims, or requests for time extension. Contractors, if you're on the line and you're a contractor, well, obviously you're going to have to submit time extension requests to the owner on behalf of yourself, and you may have to pass along or may be asked to pass along similar time extension requests from subs, suppliers, vendors, and other folks downstream in your procurement chain. And you may, in many locations around the country, you may be required to certify the validity of the subs claims if you pass them along, which could expose you to legal ramifications under the False Claims Act or something like that. If you're a construction manager at risk, again, you probably have to request time extensions from the owner on behalf of yourself, as well as those from the subs and suppliers that you believe are legitimate and should be certified to the owner. Agency CMs, or construction management agency personnel, generally speaking, on the projects where I've been involved in that had this type of contract, all claims are submitted to the CM. The agency CM was required by their contract to review all time extension requests, do an analysis, and make a recommendation to the owner as to whether they should grant a time extension or not. And then finally, of course, there's the owners. You're the folks that have to make the final decision on all the time extension requests that get sent to you. You can't just ignore them, stick your head in the sand and say, we'll take care of it at the end of the job. You have to make a decision under most of your contracts. As a result, Patrick and I have concluded that contractors, owners, construction managers, you have to know the rules concerning time extension requests in order to properly fulfill your function on the contract. Now, most contracts discuss three types of delay, and then you argue over a fourth one that may or may not be actually listed in the contract. So, Patrick, why don't you take us through the types of delays?
Thanks, Jim. As Jim indicated, there are the three major types, and then a fourth that's sort of a combination. The first is inexcusable delay, which is delay that's just straight caused by the contractor or the contractor's sub-suppliers or vendors. And then in addition, the end date of the schedule has been impacted as a result of that delay, right? There's actually a critical path delay to the project as a result of this delay. So this is the no time, no money delay. That's purely the contractor's fault, and you can see some examples there, the common reasons why there might be delays caused by the contractor that are the contractor's fault contractually. Failure to properly man the the project, coordinate equipment or material deliveries, failure to provide submittals in a timely manner, and project mismanagement. There's a sort of a sub-level to this inexcusable delay as well, that it could be delay that's foreseeable at the time of bid, where there's an example of a project where it was obvious or should have been obvious to the contractor that there was a delay. Jim, I think you have an example of this. Am I right on that?
Yeah, the most recent example, if you think back a few years when the Chinese were building out the Olympics in Beijing, it became extremely difficult, and in some cases virtually impossible, to buy steel anywhere around the world because the Chinese were buying and shipping it all there for the Olympics facilities, and it became known. It was a known problem in the industry. Steel was going to be a problem on a job. And a number of contractors, especially bridge contractors working on federal highway jobs, started filing claims asking for additional time. And the Department of Transportation and their attorneys basically put out a policy memorandum citing several older court cases saying, listen, if you bid the job anytime after this date, and that date was presumably when everybody pretty well knew the steel was tough, you're not entitled to a time extension. It was reasonably foreseeable that you're going to have trouble getting a hold of steel. And if it was foreseeable at the time of bidding, you should have, taken it into account and put a contingency in your contract. And of course, the industry is saying, put a contingency in for something that's never happened before in the history of the world. I mean, how are we supposed to deal with that? But the lawyer said, well, that's your problem, not ours. So that's the sort of thing where, if the contractor's late for something that actually was reasonably foreseeable by a bidder, they may be not allowed to get any delay. So, continuing with inexcusable delay, Patrick?
Oh, I'm sorry, Jim. That was actually the end of that. If you could go to the next slide.
Oh, I'm sorry. Yeah. What the heck's happening here?
Yeah, I'm sorry. I was confused there for a second, folks. Compensable delay is the next category, and this is as opposed to the inexcusable delay. This is a type of delay. I'm sorry. Can we go back one slide, Jim? We excusable delay.
I think something happened when these things went in. Just why don't you talk about excusable delay?
Okay. Excusable delay, and I'm sorry, it's not on the slide, but excusable delay is different than inexcusable delay because it's unforeseeable by the contractor. It is not due to the contractor's action or inaction. So it's typically a third-party delay or a delay beyond the control and without the fault or negligence of the contractor. And that would include agents, subs, suppliers, and vendors at any tier. And then again, that this excusable delay has to have impacted the end date of the schedule. So this is a time but no money type of delay. Where the contractor is typically granted a time extension but is not given extended general conditions to support that time extension. So you're looking at issues like force majeure, act of God type delays, acts of government, acts of war, fires, strikes, and freight embargoes. One example of this that I recall from my career is I was managing construction contracts on a naval base on September 11th, 2001, and because of a sudden need to upgrade security requirements on the base, most of our construction contracts were put on hold. As a result, we gave all of those contractors excusable but non-compensable delays. That's the second category. The third category, and this is consistent with the slide that you're seeing now, is the compensable delay. And this is going to be a delay where it's both excusable, meaning the contractor gets a time extension, and it is also compensable, meaning the contractor gets money to support that time extension. So unforeseeable delays caused by owners or agents or delay caused by a situation for which the owner has assumed contractual liability. And again, this is a theme, the end date of the schedule has been impacted. So these are very common types of delays in these examples: the change orders, work suspensions, delayed responses, differing site conditions, or parallel prime delays in a multi-prime contract, for instance. Next slide, Jim.
Yep.
Okay, so the fourth category that Jim and I have been sort of hinting at is concurrent delay. And concurrent delay exists when two or more delaying events occur caused by the same or different parties, when either event on its own causes a delay to the end date. So there's all sorts of debate and discussion about what constitutes concurrency. But, from a big picture perspective, you need to be in a situation where these delays are, reasonably occurring in the same time period. They might not start on exactly the same day or exactly the same minute, but they are reasonably within the same time period. They don't have to be exactly the same time in duration, but to the extent that they overlap, and they need to overlap to some extent, there is a concurrency to those delays. So it would be one issue that would be a critical path delay that is the owner's fault, and then another issue that would be a critical path delay that is the contractor's fault. And when those two are overlapping, either impacting the same critical path activity or impacting parallel critical path activities, that's when concurrency exists. And in that case, again, it becomes, it's generally handled as an excusable but non-compensable delay, although I would say that the contract language tends to dictate on that. Next slide. So this presentation is based on the George Solid Construction Company versus U.S. Decision. It provides a kind of an important outline for anyone interested in delay analysis and understanding who is responsible for what in delays. Solid, in February of '95, the Navy gave Solid a $15.5 million contract for building renovation and building an addition to another building at Naval Training Center, Great Lakes, up in Illinois. So if you join the Navy, you go up to NCTC in Great Lakes to get your initial training. It's boot camp. The contract was originally planned to run from March of '95 to May of '96. The contract was not completed until September of '96, which is 96 days late. That's calendar days. And then you can see the timeline. October '97, Solid submitted the delay claim for compensable and excusable delay. The contracting officer's final decision was that there was no time extension, and Solid appealed to the U.S. Court of Claims. Trial was held in August of '03, and then February of '05, the decision was issued. Next slide. As part of this, the court surveyed the federal court cases concerning delay, damages, and impacts going back to the early 1900s. And this was part of the judge's effort to sort of get his hands around all of the relevant case law that was in existence that would shape the outcome of this case. And as a result, the judge included his research as an index of these legal cases, which really, when you put it all together and look at it, provides a very neat and handy checklist for contractors, owners, and construction managers when dealing with time extensions. So I think what we're going to do is go through what the court cases say on the, as pertaining to different types of delay, and speak to what the contractors have to prove. And Jim is starting off with compensable delays. Jim?
Alrighty. Compensable delays are the type of delays, as Patrick said, where the contractor is entitled to receive both time as, in addition, time-related damages. So let's start off with this. The first thing the court addressed in this particular case is whether or not the government's liable if they delay the contractor's performance. And I'm going to use the word government here as we go through because that's how the court case reads. But the reality is what they're talking about is the owner. The government is the owner of this case. And this applies widely to all owners. Dependent, as Patrick said, upon the terms and conditions of your contract, of course. Anyway, the court looked at the issue of equitable adjustment, and that is a claim settlement or a change order, contract modification, whatever. And they determined that, well, if the government is liable under the suspension of work clause if the work is delayed by a government-caused suspension, and that would be either directed suspension of work or constructive suspension. And here they went back to 1970, one of the threshold cases in this area, and it's the Merritt, Chapman, and Scott Corporation case. Now, I mentioned earlier there's this 27-page white paper that supports this. All of these cases are cited fully in the footnotes, so if there's something that you want to see that may pertain to a problem you have, the full citations there, and they're all available online. The government or the owner is liable under the changes clause if a directed change or a constructive change delays the work. And again, a delay here is, as Patrick has noted, the end date of the project. And they cited the Coley Properties case in 1979. And the court noted that the owner is liable for a differing site condition under the differing site condition clause if the DSC causes, again, a project delay, and they went back to the Baldy Brothers case in 2001. However, they parenthetically commented the contractor still has to prove liability, causation, and resultant injury, citing Wunderlich in 1965 and Servidone in 1991. Now, liability, also called in the claims guys like Patrick and myself tend to call that more, use the term entitlement. They're interchangeable terms in our context. What it means is that something happened on the project, was not supposed to happen, and under the contract, the contractor is entitled to some sort of an adjustment to the contract, time or money. Causation, and that's the legal test, the contract test. Causation is that thing that happened or didn't happen properly caused the contractor to do something they would not have done if it weren't for the event, and result in injury. That's what we call damages. It cost time and money. So that's the three-part test that the Wunderlich and Servidone cases stand for. However, the court went on and they took a look at the situation. They said, well, yeah, but the government's liability is limited to unreasonable delays. So liability on the suspension of work clause is specifically called out unreasonable delays, and that's written into most suspension of work clauses in most standard contracts, at least in North America. And here they cited the John Johnson and Sons case from 1967. And the court noted that the contract anticipates a certain number of delays that are reasonable, and so you have to prove unreasonableness. And they cited Essex Electro. So what they're talking about, reasonable delay that's anticipated in the contract. You have a contract, contractor has to give you shop drawings or other submittals, and your contract says you have 20 workdays in which to respond. The work involved with that submittal cannot proceed until you've responded as the owner to the submittal. And if the owner responds in 20 days every time, there's a 20-day delay to the start of the work, but the reality is that's contemplated in the contract. If the owner takes 30 days, the first 20 is reasonable, the last 10 are unreasonable. So things like issuing change orders, investigating alleged differing site conditions, things like that, have a reasonable period of time without causing a quote-unquote delay. And the court noted, citing the P.R. Burke case from 2002, that reasonable versus unreasonable delays are dependent upon the circumstances. I live and work about 45 minutes north of downtown Denver, Colorado. Huge, well, by our standards in the Midwest, a huge town, and if I have a differing site condition claim and I need to get a geotech firm out here to investigate it to tell me, as the owner's rep, is this materially different or not, I could probably arrange to get somebody out here and, I don't know, maybe same day, definitely tomorrow morning, not a problem. On the other hand, I have also worked on projects close to the Arctic Circle in northern Alberta province, and if you're in the middle of winter, and you need a team of people to come out and take a look at something, it may be 7, 8, 9, 10 days before the weather clears enough to get a plane to fly a team of people in. And that's what the Burke case stood for. What's reasonable here may be totally unreasonable somewhere else. However, the court noted again that delays caused by defective specifications are always unreasonable from the first day that the contractor tries to work on it, and that also grew out of the Essex Electro case in 2000. And what they're saying here is that effectively the contract documents had this flaw in them the day the job was the contract was executed, but neither the owner nor the contractor recognized that until the contractor tried to comply with it. And most contractors assume that, what the owner draws or specifies is reasonably possible, so they get in there and they start working on it, and it takes them a little while before they realize this just can't be done. And so the delay caused by a defective specification starts the minute the contractor actually tried to conform to the defective specification, even before he's given notice, because defective specs have been unreasonable since from day one of the contract. Government action, the court went on to look at, the owner's action or inaction must be the sole proximate cause of the delay. Now, what does sole proximate cause means? It's the direct and the only cause of the delay. And absent that event, the contractor would not have been delayed for any other reason. And here they cited Triac Pacific in a 1992 case. And even if the owner caused an unreasonable delay, they may not be liable if the work would have been delayed for any other reason, again, going back to Merritt, Chapman, and Scott. And that starts getting a toe into the water of the concurrent delay issue, which we'll discuss a little more as we go into this thing, because this particular decision had a lot of things to say about concurrent delay. The court also noted that this particular clause, which comes out of the suspension of work, standard suspension of work clause in all government contracts in the United States, and is paralleled in the consensus stocks and AIA, I think. No adjustment shall be made to the extent that a performance would have been suspended, delayed, or interrupted by any other cause. So again, as Patrick noted, owners got a delay, contractors got a delay, they overlap, and you lose the compensability. That is the damage, the monetary damages, although contractors are typically in those cases provided with a time extension. They went on to look at, well, who has to prove the compensable delay, and then they say here clearly that the burden of proof of the compensable delay is on the shoulders of the contractor. One of the things that people always need to remember, that the burden of proof of any claim is on the shoulders of the claimant. So if you're an owner claiming liquidated damages, you have to prove the job wasn't substantially complete at the day, as of X date when you started assessing it. If you're a contractor making a claim to an owner, you have to prove that the owner delay is what caused the end date of the project to move out. So, generally speaking, I'm citing the Wilner case from 1994. The contractor has to prove the extent of the delay, that is, this event happened, and I'm 32 days, the end date of the project moved out 32 days. That's the extent of the delay. You got to prove that the owner's delay was a sole proximate cause, and the delay harmed the contractor not only from the time point of view, but I now have 32 days of extended overheads. In some cases, citing P.J. Dick and CEMS cases, both of which were decided in 2003, the contractor has to prove the owner delay was unreasonable, that it was a sole proximate cause, the delay harmed the contractor, and there was no concurrent delay. And that refers back to the previous couple of slides. And the court noted the latter test coming out of Dick and CEMS, that proving compensable delay is more complicated when both parties contributed to the delay itself. Now they get into concurrent delays altogether, and here they actually took a dive into the water, and they say, hey, the contractor bears the burden of separating or apportioning concurrent delays. Now, they went to all sorts of discussion about what exactly is concurrent delay, and citing the Beauchamp case from 88 and the Tiger Construction case from 94, they concluded in Solit, concurrent delay is defined when both parties cause delay by separate and distinct actions within the same time period. Now, as Patrick noted, and we'll talk about it a little later, that doesn't mean you both started on the 1st and solved it on the 30th. But the same time period would be the overlapping issue that Patrick mentioned. And the time and cost of the delay in this situation has to be allocated between the parties. And they went on citing the Koth and Goss case from 1944, which is like 75 years ago, and the T. Brown Constructors case, a little more recent, 1997, saying that the recovery of compensable delay is specifically barred when clear apportionment of concurrent delay is not performed by the contractor. Now, let's look quickly at the word apportionment here, okay? Apportionment in many people's mind is it's like an insurance claim when there's a car accident and both parties are partially responsible. Patrick's responsible for 40% and Zach's responsible for 60% of the damages. That's not what they're talking about here. Apportionment means of the overall, let's say, 100-day delay, the contractor has to demonstrate that if there was, let's say, 20 days that were concurrent, he's pulled those 20 days out of the compensable delay claim, making it an excusable non-compensable delay, and we're only now arguing over 80 days that were not concurrent. So when the judges use the word apportionment in terms of concurrency, that's what they're talking about. I think a number of us wish they would have explained that a little more clearly and used a different word, but that is as it is. So, citing the Klingensmith case in 84, the contractor, as claimant, has the burden of apportioning the concurrent delay. Now, this is a bit of a switch in many people's imagination. A lot of contractors believe, well, concurrent delay is an owner defense, and the owner has the burden of proving it. So, when the contractor files a 100-day delay claim, the owner is obligated to show, no, 80 of those days are on the contractor, and I only owe you 20. But that's not true, according to the courts. The contractor has to prove either there was no concurrent delay in the 100 days, or if there was some part of the 100-day time frame that was concurrent, they've removed that part. And even more serious, citing the Blinderman case in 1982, the court noted that recovery of compensable delay is denied entirely when delays that are concurrent or intertwined and the contractor has not separated this delay from the government's delay. And that makes it a little more, from the point of view of the contractors, that means you're going to have to do a lot more analysis of concurrent delay to pull stuff out, pull concurrency out before you submit it to the owner. From the point of view of the contract owners, you need to see if there is concurrent delay and see whether or not this case has any bearing in whatever jurisdiction you live in and are working in. The next thing they noted, and this is not a real big surprise, the contractor has to prove the extent of the owner-caused delay and its increased cost. So what they're pointing out here is this is like a two-step or three-step line dance. First, the contractor has to prove the extent of the owner's delay. So they have to prove it, number one, is a delay caused by the owner, and that's the only thing that caused it. Number two, what's the extent? That is, how many days did this event that the owner caused push the end date out? And they cited Servidone case in 1991 and Wilner in 1994. And then everybody says, oh, hey, I've proven the guy owes me 90 days. Well, okay, that's fine. But now you got to prove the cost of a day of delay. That's the third step. Okay, is what is the cost of a day of delay for each of those 90 days? And that will be either field office overhead or home office overhead, or both, if your contract allows it. And they go back to the John Johnson case in 1967 and the Wilner case in 1994. They dealt with a specific issue here, which I found interesting because I faced it before. Personally, on claims I've defended, the increased cost of winter construction may be compensable. So the delay that the Navy caused Solit apparently pushed some work into a winter period. Since the construction was in Chicago, you can only imagine work that might have been done in October is now pushed, say, into January. It could be a tiny bit difficult this week anyway. And so Solid claimed increased cost of winter work caused by the owner's delay as part of their damages. And the court examined that issue, and they recognized that winter work increased costs, and that's been recognized as far back as 1909, 100 plus years ago. The first court case ruled on that. And they said, hey, the increased cost and the loss of labor productivity due to winter work may be recoverable. They cited the Owen case from 1909, the Hedden case from 65, American Line Builders, 92, and Youngdale and Sons from 1993. However, they put a caveat in, said the recovery of winter construction costs is dependent upon proving that but for and only but for the owner's cause delay, the work would have been completed prior to the winter period. And they're citing here the Kitsaw-Azusa joint venture case in 1995 as proof of that ruling. Increased cost of winter work, like all other increased costs and everything, must be apportioned for concurrent delay. Again, the court kept coming back to a concurrent delay. Apparently, in the Solid case, that was a huge element of the issue. So in addition to apportioning concurrent delay, the contractor has to apportion the increased cost of the winter work. And as I said, if there's 90 days worth of winter work that would not have happened but for the owner's delay, 45 of which is concurrent with something else, the contractor's left with only 45 days for time and money, and the other 45 may be available for time only, depending on the nature of the circumstances and the language of your contract. Here they cited from 1966 the Luria Brothers case, and from 1970 the Cheney and James case. And they get back to the issue of delay itself. When establishing the extent of the owner delay to the project completion, they said that the rule is that the contractor has the burden of proving critical path delays. So to recover this, the contractor has to prove that the owner's actions impacted the critical path. And you can see the list of cases they pulled up here. The Shoup case from 84, Wilner, 94, Kinetic Builders, and Essex Electro and Sauer from 2000, and PCL Construction Services, a case that I had some tangential involvement in when I was a few years younger. And so contractors, it's up to you to prove impact to your critical path. The court provided a lengthy citation from a much older case, Haney case in 1982, to define the term critical path. But the Haney case and the court's decision in Solar really is more of a discussion than a pure definition. But Haney's discussion, as cited by Solid, conforms to the classic definition of the term critical path, which was defined by Kelly and Walker in 1958, I think, 1959. The longest continuous chain of activities through the logic network, which establishes the minimum overall project duration. So that's bottom line is they adopted the longest path definition. And they did that, pointing out in the Solid case, only work on the critical path impacts the completion date. So only critical path analysis can demonstrate the impact. And they cited PCL Construction Services and CEMS from 2000 and 2003, respectively. They noted parenthetically that non-critical path delays don't delay the project, and therefore they do not justify recovery of compensable delay. Now, what they didn't add, and I will, is that's true. If you can't prove critical path delay, you're not entitled to time-related damages. However, if you can prove delay to an activity, even though it doesn't delay the end date of the job, due to some responsibility of the owner, you may have impact damages, impact costs. And the case that I learned years ago, and it's just about 90 miles north of Chicago, in the middle of a winter like this, in Milwaukee, I was involved in a project doing waste treatment plant expansion on the shores of Lake Michigan, and work that would have been done in September and October was delayed because the owner didn't respond to some submittals on time or something. Didn't delay the end date of the project, didn't touch the critical path, but it pushed concreting activities from October, early November timeframe into late January and early February. And the question arose, well, can you really place concrete below 0 degrees Fahrenheit? And the answer is, yeah, you can. But at those days, our concrete per cubic yard was about $90 a yard in place. And the concrete in the middle of winter, because of all the protection you have to add to it and everything else, turned out to be $300 a yard in place. That's an impact cost, but not a delay. And citing the Hoffman case from 1998, when a contract utilizes CPM scheduling, a contractor has to prove critical path work was prolonged in order to prove a delay in the project completion. And that is true. And that doesn't deal with contracts that don't have critical path schedules, however. Now, the reason it doesn't is because, in my experience anyway, over the last 30 or 40 years, all U.S. federal government contracts demand CPM scheduling. However, Patrick and I have a colleague in our industry who did a PhD analysis on scheduling around the globe and concluded that less than 1/3 of all the projects in the world are actually built off of logic networks or critical path networks. So this ruling is fine, provided that the contract demands CPM scheduling. What about if it doesn't? And that's an issue that the court never addressed. The Construction Forum a few years ago, however, did publish a very lengthy, detailed white paper on how contractors and owners can deal with delay on projects that don't require critical path scheduling. And if you're interested, we'll tell you at the end of the day how you can get a hold of a copy of that too. And then the court went on to say, well, gee, we know the critical path changes over time, therefore critical path schedule updates are necessary to analyze delays. And they took into account that a critical path schedule is dynamic, citing the Sterling Millwrights case in '92, and therefore CPM updates have to be used in the delay analysis if you're going to try and prove compensable delay. And there they cited Fortec contractors in '85, and parenthetically citing the Blinderman construction case, accurate schedule updates generated during the life of the project are better tools for analyzing delay than baseline schedules. And this pretty well puts to bed the forensic schedule analysis technique of as-planned versus as-built. However, having said that, I will tell you in my experience anyway that the as-planned versus as-built is probably the most commonly used schedule delay analysis technique on a project site, not in a legal setting, but on a project site. That's the one we see the most often. Again, contractor bears the burden of apportioning concurrent delay, and they cited that some of the cases we cited earlier, but they added in this time the Avedon case in 1998, and again reiterated the point that the courts will deny recovery when delays are concurrent, but the contractor doesn't segregate them out. And they cited again, if delay is not on the critical path, doesn't cause a project delay, citing Kelso v. Kirk. And here they went back and they cited the mega construction case, which I think is wonderful. The contractor seeking recovery of compensable delay must disentangle its delay from the government's delay. This is what's called the judge here in mega construction used the term inextricably intertwined rule. That's what he set the rule. That is not possible, based on the project directors, to go through and say, oh, this day was caused by Patrick, those 2 days by Jim. You look at the 3 days altogether, you just can't take them apart. They dealt with the issue like the issue winter cost of winter work. They dealt with the issue of wage rate increases. Part of the delay claim Solent was posing against the Navy was that their delay pushed work into a higher wage rate period, and they said it may be recoverable as compensable delay under the use citing the Hedden case in '65, the Leria Brothers case. But first, the contractor still has to prove the extent of the delay, citing these two cases we've mentioned before, and they have to prove that the delayed work would have been completed prior to the wage rate increase except for and only except for the owner-caused delay. Contractor has to prove the amount of field and home office overhead related to the owner-caused delay. So, this is the third step in this three-step process. Once you've proven the owner's delay, once you've proven it was 72 days, you got to prove what's the cost of the day. And they reach back as far as the Fred Combe case in 1945, which dealt with extended or unabsorbed home office overhead. And then they reached back to the Leary Brothers case in '66, which confirmed the recovery of extended field office overhead. However, Solit was a bit different. In Solit, the Navy's contract had actually stipulated the daily cost of home and field office overhead. And so they said, if it's in the contract, folks, how to handle it, the contractor has to prove the extent of the owner-caused delay, but they're relieved of the obligation to prove increased costs. And the bottom line here, when Solit was trying to recover home office overhead using the Eichle formula, the Navy was saying they can't do that because they can't prove that their home office overhead went up. And the bottom line is that the court said, you stipulated in the contract, folks. That eliminates the need for a separate proof of Eichle damages. You simply multiply the days of compensable delay times the stipulated daily cost, citing the West v. Allstate boiler case in 1998. And that's a situation I've been often on in California, because California, the Department of Transportation, Caltrans, has a clause where the contractor actually bids their overhead rates as part of the base bid. And as a result, it gets you around all the audits, which is kind of cool because you don't have to wait for the auditor to come out and examine the books. But on the other hand, if the owner wants to object to the cost later on, it's part of the contract, and the owner's given up the rights to do all that stuff. And then they dealt with the last issue, which is a little bit sloppily worded, in my opinion. But the bottom line, when multiple delays by one party are concurrent with each other, that party's delays must be analyzed to ensure the overall effect of the multiple delays are correctly attributed. And I was on a job that I was on job off and on for 3 years that had literally hundreds of delays, many of them caused by my client, the contractor, many caused by the owner. And when you laid out on a time scale chart the contractor's delays, you found out there was a lot of concurrency between the contractor delays. So you had to take out the concurrent contractor delays before you went to the owner-caused delays and compare that to the remainder. And that's really what they're trying to say here. And they cited the Essex Electro case, v. Danzig in 2000, which is a Corps of Engineers case. The court noted, the approach of comparing one party's overall delays with the other party's delays more reliable than checking each delay for one party against all other possible delays from the other. And they're citing the Binderman case here. They also, in citing the Binderman case, they also kind of posited a form of time impact analysis, if you will, saying the only way to accurately assess this is compare the updated CPM schedules immediately before and immediately after each of the purported delays, or each of the alleged delays. So those are the rules on compensability. Patrick, you want to talk about the rules for excusable non-compensable delays?
Yes, I would. Thank you, Jim. So excusable, compensable, as Jim mentioned earlier, the government has that initial burden of showing that there was late completion, and the contractor has the burden of showing that the delay was excusable. That first burden on its face seems pretty easy, that the government has the initial burden of showing late completion. I've actually been involved in a case recently, however, where there was substantial disagreement about what the word or what the term substantial completion meant, such that the contractor was insisting that he had met substantial completion per the contract about 6 months earlier than the owner believed he had met substantial completion, and that actually created an interesting wrinkle in that case as far as what substantial completion actually meant. And given that the liquidated damages were tied to the substantial completion milestone, it was a pretty big swing in the amount of money that the owner believed they were owed. So on its face, the government showing that the contractor finished late is not necessarily as easy as you might think. But the next part is definitely difficult, that the contractor has the burden of showing that the days of delay, that the delay was excusable. So the government, as we said, has to prove that the project was not substantially complete, and then separately that the period for which liquidated damages were assessed was appropriate. And then from there, and this is citing to the PCL decision, the contractor has the burden of proving excusable delays to show that they should be reduced or eliminated entirely. Next slide.
Hang on a second. Yeah, there we go.
Right. So when the government prevents the contractor from completing the work on time, the contractor is relieved of the obligation to meet the contract completion date and not obligated to pay liquidated damages. And this is the basis. These decisions that are listed there, Schmall and Levering, are the basis of the excusable delay. And the court noted that when the delays by the government action or inaction, there's some controversy in the case law about whether the liquidated damages are entirely voided or simply reduced consistent with the apportionment of delay. There's a very interesting split here between these cases. And again, from a big picture perspective, I'm sorry?
Nothing.
Oh, if the contractor finishes, if the government prevents the contractor from finishing late, the discussion within the case law is, does that mean that the liquidated damages clause is entirely voided? Next slide, please. So it's ultimately the court in Solid concluded that apportionment versus waiver is an unsettled issue. If you could go to the next slide, the waiver, as is noted in the cases listed there, United Engineering, Acme Processing, and PCL, points to an idea that when there is government-caused delay, the LDs are entirely waived. But if you go to the next slide, please, Jen. The court noted that rule, the waiver rule, was criticized in Wallace and again in PCL, which listed cases ignoring the rule. But then in Solid, the court also discussed cases in which the court ignored the waiver rule entirely and relied instead on apportionment. And apportionment, I think, is just generally understood that if we are splitting delay, if there was, for example, 150 days of delay on a case, but the owner is found to have caused 60 days of non-concurrent critical path delay, then the contractor gets that 60-day time extension, but the remaining 90 days in this case are assessed as part of a liquidated damages clause. So that's apportionment, and the court discussed those cases in which those apportionments are used, and the waiver rule is criticized overall. Next slide. So ultimately, this is an unresolved issue according to the Solid decision. And Jim, unless something's come out within the last couple of weeks, I think it's still unresolved. Is that correct?
Well, yeah, I was about to comment. In the court, maybe you're right, insofar as that there's no particular compelling decision that binds all other courts in the country, like a Federal Court of Appeals for the Federal Circuit. However, I would tell you, I've been in this business 47 years, and I have never seen liquidated damages completely waived unless the contractor could prove that all 100 days of delay were concurrent with all his delay, and that I've never seen that. So I I would say if you're a contractor going to try and argue that, because of concurrency or whatever, all liquidated damages are gone, you ought to talk to your attorney before you make that statement to the owner, because I'm not sure many owners are going to buy that, frankly.
Yeah, and I think we established at the top that I can't claim 47 years of experience, but in my nearly 25 years, I have not seen that either, that that anything other than the apportionment rule being implemented.
Yeah, no, I think that's probably safe to say that's probably 99.9% of the cases you and I have ever been involved in do that.
Yep.
Okay, now let's take a look at some more recent developments. Solent was decided by the Court of Federal Claims in 2005. Subsequently, there have been two other decisions reached that kind of go into this area of time extension requests. What does a contractor have to prove? The first is Meropakis, which is a U.S. Court of Appeals for the Federal Circuit. For those of you not familiar with the federal legal structure, this is probably the second highest court. I guess it is the second highest court in the United States. The only place you can go from here is directly to the U.S. Supreme Court. And more importantly, because it's for the Federal Circuit, decisions out of this court actually control or set precedent for all other federal courts across the country. And the reason I say this is such a high court is because, frankly, I can't recall the last time the United States Supreme Court accepted a construction case. They have enough to say grace over as it is every year that I don't think construction cases rise to their level. The other one is the Weeds Company versus Washington. It's an Eighth Circuit Court of Appeals in 2011. It's a little bit narrow, but the idea here is that both of these decisions may be game changers with respect to delay claims. So let's start with Meropakis. I don't want to beat up on the Navy, Patrick, but this is another Navy case. The background of the case is fairly simple and straightforward. Navy gives its contract to Meropakis in 1999. The original time of completion was mid-January of 2000, later modified by contract modification to early February. Must have been a relatively small case or contract because the liquidated damages were $650 a day. Meropakis didn't commence work until after the contract completion. I don't know why the Navy didn't terminate him, but that never came up in the decision, so there must have been some compelling reason they didn't. And Meropakis didn't complete the work until mid-May of 2001, 467 calendar days after the modified completion date. Now, after completion of the work, Meropakis sends a letter to the Navy asking for a 447-day time extension based on 5 different delay events. Apparently, they were willing to fess up to 20 days of their own cause delay. But Meropakis did not certify the claim, nor did they request the contracting officer's final decision, both of which are clear requirements of the Federal Contract Disputes Act, a statute that governs all federal contracts direct federal contracts around the world, whether it's mentioned in the contract or not. 3 months after they get this letter, the contracting officer notifies the contractor, the information's insufficient to justify a time extension, and they invited him to submit further documentation. 10 months after that letter from the Navy back to the contractor, the Navy notified the contractor, you haven't submitted any additional information. We're going to close out the contract, so we're going to impose $300,000 in liquidated damages for your 467-day late completion. A month later, Meropakis sends another letter requesting a time extension. They mentioned 5 delay events. They only discussed 1, and they asked for 107 days, dropping it from the 447 of their earlier claim. In December of 2002, the contracting officer apparently said, here's my final decision concerning the assessment of the LDs, and they pulled the $303,000 out of the remainder. And the Navy, and that letter from the contracting officer back to the contractor is important because they later contended that final decision issued by the contracting officer only addressed liquidated damages, not the delay claim in and of itself. A year later, having blown the time to go to the Armed Services Board of Contract Appeals, you have to file that appeal, I think, within, I think it's 90 days or something like that, or notice of appeal. They file a claim lawsuit in the Court of Federal Claims. Not surprisingly, the Navy responded by counterclaiming the liquidated damages. But what was a surprise to Maripakis and to a number of people in the industry, the Navy also asked the court to dismiss Maripakis' delay claim for lack of jurisdiction, saying the contractor had never submitted the claim under the Contract Disputes Act. The court took a look at the thing and said, yeah, you're right. The liquidated damages, we stand behind them. And Mr. Maripakis, you're not going to be able to discuss your claim at all in front of us because you didn't go through you didn't touch the bases you're required to touch under the Disputes Act. Maripakis appealed this thing to the Court of Appeals for the Federal Circuit. They contended three things. Number one, that the letters to the CO, the contracting officer, constituted a valid claim sufficient for the Court of Claims jurisdiction. They argued that even if it wasn't in technical compliance, the Navy had enough to know about it that they should have allowed it to go. The Court of Appeals reviewed the situation and determined, one, that Maripakis didn't submit under the Contract Disputes Act, and they didn't request the contracting officer's final decision, both of which are factual findings and no big surprise there. They ruled that the Court of Claims acted properly in dismissing the claim for lack of jurisdiction. But then they decided, they asked themselves a separate question that was not particularly raised, I think, in the filing by the contractor. Should the contractor have been allowed to present their delay claim as a factual or an affirmative defense against the assessment of liquidated damages? And the court reviewed and noted, number one, the Navy's claim for liquidated damages is an owner claim. A government claim doesn't have to be certified under the Act because the Contract Disputes Act only applies to contractors. Navy did make the final decision, and therefore the Court of Claims had jurisdiction over that issue, the imposition of LDs. But then they examined the issue of whether the contractor must submit a certified delay claim in order to defend against liquidated damages. And they reached back to the Sun Eagle case, 1991, and found this citation. When a plaintiff is challenging a government's claim to liquidated damages and the owner is making a claim to recover the amount withheld for liquidated damages, the contractor's claim must first be certified under the Contract Disputes Act. And citing an even older case, Elgin Builders, where a contractor seeks to contest liquidated damages by claiming entitlement to a time extension, this is a claim against the government, which must first be presented to the contracting officer. So the contract, based on all this, the Court of Appeals ruled the contractor seeking an adjustment of contract terms has to meet the requirements of the Contract Disputes Act, whether asserting a claim against the government or asserting a defense to government action. The bottom line on Maripakis is contractors can't raise excusable delay claim as a defense against liquidated damages unless they've submitted a certified claim to the contracting officer and requested final decision. In summary, Maripakis, 9 years after project completion, 7 years in court, the contractor was never allowed to present even 1 hour of their claim to argue against the Navy on the Navy's delays. Based on the Court of Appeals decision, and this is where the game changer comes in, contractors cannot raise excusable delay as a defense against liquidated damages unless they've submitted a certified claim to the contracting officer and requested and received the contracting officer's final decision. That is completely different than anything that most of us have seen in our careers, because normally the minute the owner imposes liquidated damages, the contractor yells concurrent delay, and it's been allowed to go in arbitration and litigation. But what this court's saying is that's wrong. If you haven't filed the claim properly under the Act, or in some cases, I saw one in California recently and another one in Michigan, if you haven't submitted the claim in exact accordance with the terms and conditions of the contract documents, you've lost your right to argue this later on. That is a game changer. The Wheats Company is a bit different. It's a very narrow issue, but we bring it up because it was interesting. This is a case that really involved a project that did not have contemporaneous schedule updates. Now, this is an appellate court case out of the Eighth Circuit, so it only applies to the Eighth Circuit, I believe, is in the Midwest. In the district court case, Washington argued that Wheats's expert, Mr. Brannon, his testimony should have been excluded by the court. Brannon had been retained by Wheats to analyze project delays, establish causation, assess responsibility, the classic forensic schedule analysis thing that Patrick and I have done. Brannon compared Wheats's original schedule to what he called contemporaneous updates, but we'll find out in a couple of minutes they really weren't quite that. Now, the district court termed the forensic analysis Mr. Brannon used as windows analysis, or what they said, events as they actually occurred. I do have to caution you that term is heavily overused, and so saying it's a windows analysis, out of the 9 forms of forensic schedule analysis that are recognized widely around the world, Patrick, I think it's 5 or 6 of them also go into the term windows analysis. So it's a pretty broad-reaching term. Anyway, Washington argued that Brannon's analysis is unreliable because it allocated most of the work to the critical path on the baseline schedule and didn't distinguish between critical and non-critical. And they said, Brannon's actual forensic schedule analysis, the baseline was actually Brannon's own creation, and he couldn't identify whether each activity was on the schedule was critical or not. And so what it turns out is that apparently there was only a very baseline schedule, a very simple baseline schedule. Brannon had to flush it out to create logic, and then he used other project records and perhaps the recollection of people who actually built the job to come up with the schedule updates, and that's how he did his analysis. Now, Wheats countered that Brannon's experience on similar projects is that near critical path activities should be analyzed as critical since float on the baseline is so small. Near critical path is a term that a lot of people use. I don't believe there's actually a formal definition of that term. What I use as the term is that a near critical path is any chain of events or activities, rather, that has less than 1 reporting period's worth of float on it. So I've got a critical path, that's the longest path, and if your reporting period is every month, 30 calendar days, anything with 30 or less calendar days is near critical path. And the reason I think a lot of folks like myself go along with that is that in any one reporting period, any 1 month, something could happen, and that critical path, that near critical path, could become the critical path. And that's part of the dynamics of the CPM schedule. Now, the appellate court summarized rules regarding admissibility of evidence, and I'm not going to go through those. They're here on the slides, or they're discussed in the white paper if you want to see that. But what they finally concluded is that, the district court has said, there's some weaknesses in Brannon's analysis, but not enough to make it unreliable, sufficiently specific to allow Washington to challenge and demonstrate the flaws. And the argument over what's on or not on the critical path doesn't render the analysis totally unreliable. So they concluded that the district court is right not to throw out Brannon's analysis. So the bottom line here, though, is that contemporaneous critical path testimony by an expert may not always be required to sustain the burden of proof on delay and delay damages. Now, this ruling would apply in this particular case. It applied because the contract did not call for a critical path schedule. So unlike the ruling that we talked about in Solid, where it said, you have to have critical path delay, you have to use critical path updated schedules to do the delay analysis, this deals in part with the issue of what happens if you're on a job that's not run off of a critical path schedule. And this is the ruling here. So that may be something of a game changer also. However, having said that, Patrick, you want to kind of summarize the checklist for time extension claims?
Sure. Based on what we've talked about, this boils down to the overall checklist for time extension requests. So this is the answer to the question, what does a contractor have to prove? So with regards to compensable delay, the government is liable for equitable adjustment when they cause the delay to the contractor's performance. but the government's liability is limited to unreasonable delays under the suspension of work clause. The government's action, lack of action must be the sole proximate cause of delay, but the burden of proving commensable delay falls on the contractor as the claimant. Next slide. So the contractor bears the burden of separating and apportioning concurrent delays, and the contractor must prove the extent of the government's delay and increased costs to recover the damages. And the increased costs of winter construction may be recoverable, provided the contractor can demonstrate the work would have been completed prior to winter, but for the government delay. And the increased cost of winter work must be apportioned if there are concurrent delays. Next slide. When demonstrating the extent of government delay, the contractor bears the burden of proving critical path delay, but because the critical path changes over time, the critical path schedule updates are needed to analyze delays. That's assuming that they are, in existence and reliable. The contractor bears the burden of apportioning concurrent critical path delays, and the contractor may recover wage rate increases that would not have been incurred but for the government delay. Next slide. The contractor has to prove the amount of home and field office overhead directly related to government delay. And when the parties stipulated daily delay costs, the contractor must prove the extent of government delay, but is relieved of the obligation of proving the increased costs. And when multiple delays by one party are concurrent with one another, that party's delays must be analyzed to ensure the overall effect of multiple delays are correctly attributed to that party. Next slide. For excusable delay, the government has the initial burden of showing late completion, and the contractor has the burden of showing that the delay was excusable. And when the government caused part of the project delay, the liquidated damages are either waived or apportioned, and that, as we said, is sort of an unsettled case in the law apparently, but we sort of see it one way normally in action. Next slide. And Jim, recent developments.
Yeah, the recent developments, the contractors actually have to file a claim in accordance either with the statute if you're under a federal contract or with the contract language itself, and receive a decision from whoever the deciding official is. Contractors, you're no longer safe waiting till the end of the project to assert concurrent delay as a defense against liquidated damages. And that's we're starting to see that rule spread across the country in numerous government contracts other than federal contracts. And then, as I said, critical path testimony by an expert may not be required to sustain the burden of proof concerning delay and delay damages, depending upon the nature and the terms and conditions of the contract. With that, we have